And Phoenix versus Powell and Pratt. It's 24000014 LT. Matter set for 10:30. Now 11 o'clock. Do we have landlord on, Derek Phoenix?
Yes.
All right. And do we have Powell and Pratt? Yes, looks like we do. All right, so Mr. Phoenix, is the matter still in dispute?
I'm
You're
sorry.
still looking for return of the You're still looking
Yeah.
for return of the property?
Yes, sir.
All right. And so turning to the tenants, are you disputing the matter? Or are you going to be removing yourselves from the property, or do you want to remain? What's the status here?
Well, if I'm able to apply for assistance, wanted to make sure I could do that.
At the same
Well, you
time,
can apply, you can always apply for assistance. That's not the issue before the court. This gentleman wants his property, this gentleman wants his property back. And the question is, are you going to voluntarily turn it back over to him, or do I need to set it for a hearing?
at this time, I mean, it's more so of a hearing, but also our lease property is under residential investment and commercial investments LLC, not Derek Phoenix, unfortunately. The owner of the property is his business.
Hold on. Is there a lease, sir?
I'm sorry. Say it again.
Is there a written lease?
Yeah, it's a lease.
Well, you need to attach the lease to the complaint. The complaint tells you that. Is the lease in your name or in a LLC or corporation name?
It's under the LLC, but the lady at the courthouse told me that if I didn't have the lease, that I didn't have to attach it.
Well, that's not true. I find that hard to believe that she would have told you that. If she did, she's clearly wrong, and she's not supposed to be giving you legal advice in any event. I'm going to set this for hearing. Listen to me, sir. I'm going to set this for hearing, but you need to get an attorney if the lease is in the LLC. Unless you're a licensed attorney, you can't represent the LLC. So I'm going to set it for hearing. That hearing will be January 24th at 1:45, but you're going to need an attorney to proceed with that matter, sir. If you don't, the matter is going to be dismissed. And as I indicated, if you're going to file complaints against tenants, that's fine. But if you have written leases, you need to attach them to the complaint. Regardless of what anybody else might tell you, that is required, all right?
Certainly, but Your Honor, may I ask a question? So
Yep,
my daughter and my son got into my all my legal documents, and a lot of them got misplaced or threw away. So if I didn't have a lease, then what would I have? How would I proceed?
Well, that'd be a different situation, but you've already acknowledged to me that there was a written lease. They're indicating, the tenants are indicating there's a written lease. I asked you if it was in the LLC's name. You indicated yes, it was. So I'm just telling you, in the future, if you're filing any complaints, you need to attach the lease. And like I said, we'll set it for hearing. And sir, you're going to have have representation. Otherwise, I can't proceed at the hearing because you're not a licensed attorney in the state of Michigan and you can't represent the LLC. All right?
So do I have to go through the whole process again, or is it still
No, it's still alive at this point, but you're going to need counsel, sir.
Okay. And so it is a lease, but I lost my lease. They still have their lease,
Yeah.
but I lost.
I understand that. And I understand that. You explained that.
All right. So how do I go about that part?
we can provide.
Well, you don't
you
have, they'll provide a copy to you.
Okay.
They'll give you a copy, but you've already acknowledged the lease in any event. So for my purposes today, we're all set. All right, we'll set for hearing January 24th at 1:45. Thank you.
All right.
Thank you.
Yeah, thank you. You're all set for today. Ms. Scheck, you have Cardinal Corners LLC.
I do, Your Honor.
right, and let me see where we're at with this.
I can bring the court up to speed, Your Honor. We originally were here for a landlord-tenant issue. The first hearing was held on December 12th, at which time the tenant failed to appear. However, on the 18th, I believe, she made a large payment that paid the balance off. So I submitted a dismissal to this court on December 19th. Shortly thereafter, my client was notified that that check bounced back. It was not a good check. So I did file this motion to set aside the voluntary dismissal and reinstate the eviction. In the meantime, my client has met with Ms. Gadali and is willing to work with her. I myself have spoken to Ms. Gadali. I believe we have a consent judgment today, Your Honor, that we can put on the record. She's advised she wishes to stay there.
All right. Ma'am, is that your understanding, Ms. Gadali?
Yes.
Page 5, first one is elbers and inches. All right, so you're acknowledging that the matter needs to be, the dismissal needs to be set aside because of the check issue, and you're acknowledging that you're consenting to the judgment. Is that correct?
Yes.
All right.
Your Honor, I can put the
You
numbers on the record.
understand?
Oh, sorry.
Yeah, go ahead, Ms. Shaw. No, go
Okay.
ahead.
Your Honor, for the possession judgment, rent to retain possession, $3,483.93. There are utilities that total $79.64. And then there is an NSF fee of $35 for that bad check. Total is $3,598.57. Court costs total $246.72. Total possession judgment, $3,845.29. We are going to do a writ date of February 11th of 24. As for the money judgment, Your Honor, rent to retain possession, or rent, I'm sorry, on a per diem basis, $3,145.27. Same utilities of $79.64, same NSF fee of $35. Total $3,259.91. I add my statutory court costs of $246.72. Total money judgment, $3,506.63. I did explain the difference between the two of those to the tenant. She does not have to pay both, only one of them, depending on what she wants to do. The only thing I did not do, Your Honor, was explain the court rule to her. Ms. Gadali, because you're here without an attorney, if you go home and feel that you made a mistake or did not understand your rights here today, you do have 3 business days to come back to Judge Hoffman to set this aside and set it for trial, okay?
Okay.
So, ma'am, you are consenting to that judgment under those terms?
Yes.
And you understand you have 3 business days in which to withdraw your consent because you're not represented by an attorney, correct?
Yes, Your Honor.
Okay, you're all set then. We'll enter that consent judgment. Thank you,
Okay.
counsel.
Thank you.
Thank you.
Appreciate everyone's
Yeah,
time.
thank you, ma'am. Thank you.
That's it, Judge.